Okay, I think that we may just start our panel because what?
What is this?
Okay, let's start our panel, which is consigned for the 5:30, and it's already 5:50. 20 minutes, of course, coffee break is always longer than it should be. That's why I would like nonetheless start our panel. I'm so sorry, but we have only 1 hour and 30 minutes. Still, I think that it is 1 hour 30 minutes because I cannot imagine that our panelists will speak shorter than 10 minutes, and we have 8 participants from different countries, from different continents, so at least 10 minutes for each person. But I would like you to ask to just limit yourself to 10 minutes, and if you allow me, I just break you, and being very sorry for doing this, but I have to as a moderator. And I would like to ask Mrs. Golonka from the University of Rzeszów, who is online. Is Mrs. Golonka present?
Yes, I am present, but sorry, I had a problem with login, so I'm as a user, not in my name, but I'm absent and I'm prepared. Although there are some, okay, it's better. Is everything okay? I cannot hear you, sorry.
Yes, you can hear me now?
Yes, I can hear you, Ms. Professor, yes.
Could you start your presentation or your statement, having in mind that we have only 10 minutes for each person?
Yes, I know. I tried to show you my presentation, but I have some problem. Maybe if it will be not possible to present or show presentation, I'll try to only speak because I'm very limited in time. So why I chose this problem, I mean money laundering as a crime, and I connected it with sustainability because money crime is in fact a very serious crime. It has a complex nature. It's actually illegal process of making large amounts of money generated by criminal activity such as drugs trafficking or terrorist funding. Also, some so-called green crimes that are preceded crimes, so it's a slow way to connect to sustainability, because some crimes can be also predicted, I mean source crimes of money laundering. And if I could say what it has common in sustainability, in fact, there is not direct connection. Sorry, I still cannot open my presentation because I have no possibility in this kind of. So sorry. Let me give my speech so by heart simply. What it's also from my point of view very important that because of this severity of this crime, it's probably even more than 87 trillion euros. It's supposedly to be laundered every year. So very big amount of money. The crime is so serious that there have been taken a lot of steps, also both on international level as on internal level. I mean, of course, about I talk, of course, about legislative steps on the level of European Union law. It was established AML package. It's a set of acts, legal acts, and it consists of 3 regulations, which can be direct, without implementation, which are in force, and one of this regulation, the purpose of one of this regulation is establishing the AMLA. I mean, it's authority which aims to fight with money laundering. Its aim is to protect the stability and integrity of the European Union financial system and to proper functioning of international market. And how can the European Union AML package, so anti-money laundering package, can be linked to sustainable development goals? First of all, in the economic aspects, it protects financial stability. It reduces the shadow economy, increases tax revenue, encourages legitimate investment. What about the social context? Sustainable development helps educate about corruption and inequality. It serves to strengthen the law, protects individual rights. And in terms of environmental, we can see legal wildlife trade, waste trafficking, and so on. When I would say something more about, so maybe more specifically about SDG, I could mention definitely about SDG 16, I mean peace, justice, and strong institutions. And it could be the primary goal of sustainable development aligned with AML. Mention package, I mean AML European Union package directory, suppresses illicit financial flows and organized crime in all forms. So it's in this kind, it fulfills objective 16.4, I mean reducing illicit financial flows and combat all forms of organized crime, as well as the next one, objective, I mean, it reduces corruption and bribery and all the forms. What's more, it helps, of course, also developing effective, accountable, and transparent institutions. So also objective 16.6, the next one, is achieved, can be achieved by AML package. Actually, when I could talk more about it, I can mention about once more or even 2 more goals, 8.1, a decent work and economic growth by promoting development-oriented politics that supports productive activity, or adopts fiscal and social policies to progressively achieve greater laundering. But I have also in the theme of my speech some tips how we can reach a better way to fulfill all SDG goals by using new technologies. I mean, first of all, a powered AML compliance framework, so we can use, generally speaking, AI, artificial intelligence, also supported by machine learning. It can help by reducing risk by generating some formulas that are obliged for some institution that take part in the whole AML system. Like, for example, political spokespersons' declarations. This softwares also can be helpful by verifying customs and beneficial owners. But unfortunately, there was research carried out by AKAMS. I mean, it's association specialist that aims also fight against money laundering, and according to this research, only 18% of all generally speaking persons, because that are not only companies that are obliged to fulfill some formulas and take part simply in the system of AML. Only 18% use AI software in their work. What's more than half of all companies that are obliged to fulfill this report use and plan use machine learning and more specifically equipped software like generative artificial intelligence. And what can be interesting, that nearly 80% of them find out that it'd be very supportive to use such a software in their work. If I could try to guess what are limitations and the reason why they don't use such software, of course, most important and the most obvious one is actually are budget constraints, also low level of trust in process automation, and also I think that maybe in some cases staff shortages, like people operating technologically advanced systems. So I think that in general, system limitations can also be point out, like the kind of limitation to use in AML system new technologies. That's all. I'm sorry about some problems and other disturbation that I had with my speech. I can tell also, I can say that everything will be, I hope, on paper, and maybe more will be written, to be possible to read it out when it was some problems. It was not perfect. Thank you very much for possibility to give the speech. Thank you.
Thank you for your contribution, and I would like to ask Mrs. Natalia Lipa from the University
Yes,
of Poland.
I am
Yes?
here. I am online.
Yeah, I know. It's pity that you are not here in Krakow, but nevertheless, I would like to ask you to present your topic, which is due diligence as a tool for sustainable supply chains in the art market, a Polish and EU legal perspective. I assume that you have also some connection with Professor Stets, because I am
Yes,
right? Yeah,
yes, yes.
he's also dealing with this question of the art market. Okay, could you please present your topic, and if I may just ask you to concentrate your speech and to speak with 10 minutes only. I'm sorry, and at the end I will have to interrupt you if you will talk longer. Okay.
My topic is about due diligence as a tool for a sustainable supply chains in the art market, Polish and European Union legal perspective. Products available on the art market should be produced and traded in a lawful manner with respect for human rights and the natural environment, the protection of culture heritage, transparent and ethical trade in work of arts, our prevention of trafficking in culture goods constitute elements of so-called culture sustainability, a concept that assumes the preservation of culture assets and identity for future generations. With the dynamic development of the international art market and the emergence of new forms of trade, legal problems related to the lack of transparency of transactions and the illegal origin of artworks have become increasingly apparent. Obligations related to due diligence may contribute to the creations of sustainable and responsible supply chains in the art sector. In this context, I propose to view the art market as a specific type of supply chain in which culture goods are subjects of trade. In the field of art, the concept of a supply chain may be understood as a chain of ownership and provenance of artwork from the artist through galleries and auction house to a private collectors or museum. Responsible management of this chain requires market participants to implement due diligence mechanisms corresponding to those applied in high-risk sectors, such as the trade in raw materials, the garment industry, or electronic manufacturing. In practice, this entails the verifications of the sources of artworks, the examination of legality of their export or import, and ensuring that transactions comply with national and international legal regulations. Works of art constitute a specific object of economic trade due to their unique characters, their material and immaterial value, and the particular nature of the market in which they circulate. As a rule, they are subject to general regulations governing commercial transactions applicable to other goods. In the same time, artworks are exceptional and non-repeatable, which distinguish them from mass product commodities. They also represent an important element of national culture heritage. The trade in works of art takes place on a specialized market involving not only private collectors, but also auction house, art galleries, museums, and foundations. In practice, artworks often pass through many hands, from artist or the original owner, through galleries and other artists, then auction house, and finally to private collectors. The multiplicity of entities involved in the trade in works of art makes the obligation of due diligence particularly significant. The first, due diligence operates in two complementary meanings. It functions as a standard of care defining the level of cautions, knowledge, and proofs that may be required from a participant in transaction under specific circumstances. Second, due diligence is understood as a process, namely a set of functional and legal actions aimed at examining whether the required standard of care has been observed given situations. In this sense, the due diligence process constitutes a practical tool for the implementation of the duty of care through the assessments of the acts of diligence undertaken by a given entity. When conducting a due diligence examination, a party is required to exercise a level of care that can reasonably be expected from that entity in the specific circumstances, taking into account by applicable legal provisions and the obligations incumbent upon it. Due diligence is not only a process, but also a result of collecting and analyzing information concerning the subject matter of planned transactions. And this procedure may relate to any object of a civil law, contract, or other legal act resulting in the transfer of ownership or possession of property. In the art market, the aim of this process is to eliminate the risk of acquiring objects with an uncertain legal status or originating from illegal sources, as well as ensure that an artwork may be safely introduced into circulations or incorporated into an institutional collection. In the Polish legal system, there are no single comprehensive regulations devoted specially to due diligence in the trade in works of art. Due diligence constitutes integral elements of Polish legal institutions in which the concept of care is understood as assessed in various ways, depending on the factual circumstances. There's obligations operate on three levels: the due care required in the performance of an obligations, the diligence of the acquirer understood as acting in good faith, as well as specific acts of diligence undertaken by the parties to transactions during the purchase, sale, import, and export of goods. Together, these elements from a common framework of responsibility and conduct expected from both professional and non-professional market participants. And it's the other regulations selected. The Act of 23 July 2003 on the protections of monuments and care of monuments introduced obligations to the documents in the provenance of monuments to obtain permits for their export and to notify heritage protections authorities in cases of suspected illegal origin of an object. These national regulations are supplemented by European Union law, in particular regulations EU 2019/880 on the introduction and import of culture goods, which impose on importers the obligations to present evidence of the lawful export of cultural objects from the country of origin. Also significant is Directive 2014/60/European Union of the European Parliament and the Council of 5th May 2040 on the return to culture objects. Equally important is the Act of 1st March 2018 on the prevention of money laundering and terrorist financing, AML Act. Against the background of the above regulations, is particularly interesting to refer new trends in European Union law, especially those resulting from Directive the 2024/1760 on corporate sustainability due diligence, CSDDD. This directive defines due diligence as obligations to identify, prevent, and eliminate negative impact of business activities on people and the environment through the entire value chain. In conclusion, due diligence is in the circulation of works of art may be understood not only as legal obligations, but also as a tool for sustainable governance of the art market. Embedding this concept within the broader framework of sustainable development allows the protections of cultural heritage to be treated as an integral component of responsible economic activity. It also makes it possible to recognize that the protection of cultural heritage is not only solely the responsibility of the state, but also shared responsibility of a private actors, participants in the market. In this sense, due diligence in the art sector may be regarded as an instrument for implementing the principle of intergenerational solidarity, which constitutes one of the pillars of sustainable development in European Union law. Thank you.
Thank you for your very interesting contribution. I'm so sorry, but I cannot ask you any question because we need to proceed to another participant, who is Amelia Georgescu from the National University in Bucharest, in Romania. Mrs. Georgescu presents us the topic, legal instruments and the intersection of intellectual property law and sustainability. Mrs. Georgescu, you are present online. Could you please share us with your presentation or start your statement? You are very welcome.
Yes, thank you. Good evening. Thank you for the invitation to Professor Marius Zaluki. It's a pleasure and an honor to be here with you. Online is true, but also is in this way is a pleasure and an honor to be with you. I share my presentation. 1 minute, please. I hope everybody can see my presentation.
Yes, we can see wonderful presentation. Please start your presentation.
Yes, the convergence of intellectual property and the sustainability represent a paradigm shift from the individualistic mercantilist view of patents toward the social utilitarian function. In the European Union, this is anchored in Article 37 of Charter of Fundamental Rights, which mandates that environmental protection be integrated into union policies. Within the Romanian legal framework, this intersection must be interpreted through the lens of Article 44 of the Constitution, which stipulates that the right to property carries with it the obligation to comply with duties related to environmental protection. Thus, the patent holder's right to exclude is not absolute, but is delimited by the collective right to a healthy environment. The European Patent Office provides a PACE program for accelerated prosecution of European patent applications, which is frequently utilized for green technologies. In Romania, law number 64 from 1991 on patents allows for accelerated procedures, but a specific green track would provide the necessary predictability for investors in the circular economy. A major legal concern discussed in current doctrine is the risk of greenwashing. If the criteria of green are too broad, the patent system risks being cluttered with pseudo-innovations. To mitigate this, legal instruments must align with the EU taxonomy regulation number 852 from 2020. This ensured that only technologies providing a substantial contribution to environmental objectives, such as a climate change mitigation or the transition to a circular economy, benefit from fast tracking. The TRIPS agreement remains the backbone of the global patent regime, but the offer states levels of flexibility. The implementation of this flexibility including mechanisms for production, export in certain scenarios, has been multiplied by post-TRIPS interpretations and practices. Thus, the international regime recognizes the possibility of public interest measures regarding patents. The Paris Agreement established a policy framework to promote technology transfer in combating climate change, creating the basis for multilateral and national instruments aimed at facilitating technology exchange. At the European Union level, the Commission has launched legislative initiatives aimed at harmonization, the possibility of using compulsory licenses in crisis scenarios, and has launched consultation documents and impact assessments exploring instruments for ensuring access to critical technologies in times of emergency, proposing an EU framework for compulsory licensing in crisis management. The global climate challenges forces regulatory systems to reconsider the relationship between private rights and the common good. Intellectual property, especially patents, was designed to stimulate innovation by granting a temporary exclusive right. In the context of the climate emergency, delaying access to essential technologies can cause major public harm. Thus, formulating mechanisms that simultaneously stimulate investments and accelerate the diffusion of green technologies becomes essential. This paper starts from the question, through which legal instruments can intellectual property law become a catalyst for the transfer of green technology without breaking down incentives for innovators? Tool number 1, green patent fast tracking, rational models and limitations. Patent examination procedure for inventions in areas considered a priority for the environmental constitute an administrative policy aimed at reducing the time between invention and market launch. The motivation is clear. A faster examination reduced the time to market and allows the adoption of technologies necessary to achieve climate goals. Administrative examples implemented in various patent offices show that it is feasible to allocate examination resources and optimize procedures with the effect of accelerating patenting for technologies with a climate impact. However, accelerations do not solve the problem of access in itself. It can even intensify the monopoly premise if holders use rights to limit diffusion. Therefore, fast-tracking must be combined with transparency conditions, strict eligibility criteria, and clauses that encourage subsequent mechanisms for accessible licensing. Administrative cost-benefit analysis indicates that large patent offices can absorb this procedure more efficiently. Conversely, equitable global implementation requires support for offices with limited capacity, as well as common standards for determining the greenness of technology. Tool number 2, patent flexibility, compulsory licenses, public interest exports, and voluntary mechanism. Compulsory licenses are essentially the legal instrument by which a state or a competent authority can allow the use of a patent invention by third parties without the consent of the patent holder in return for equitable remuneration. The TRIPS regime provides scope for such measures in the public interest. Practical implementation varies between jurisdictions. Recent initiatives at European level have discussed the harmonization of compulsory licensing mechanisms for crisis situation, with legislative proposal and working documents aiming to create clear and predictable procedures for granting licenses in emergency situation. Voluntary mechanism, open licenses, patent pools, and technology transfer platforms offer flexible alternatives for diffusion of green technologies. This can combine fair, reasonable, and non-discriminatory standards with efficiency conditions for licenses, allowing for scaling up production and local adaptation of technologies in developing economies. The comparative assessment shows that voluntary licenses are preferred by industry because they preserve commercial control and remuneration, but are insufficient where markets are fragmented or where commercial interest in certain technologies is limited. Compulsory licenses, while effective in ensuring access for public purpose, can have adverse effects on research investment if used inefficiently or abusively. Hybrid mechanism in which compulsory licensing is reserved for well-defined situation and voluntary mechanisms are incentivized through conditional public procurement and administrative facilities seems the most reasonable. Conceptually, EcoJustice suggests that law should fairly balance the demand of present and future generations. Applied to patents, the dictum private law with public obligations makes sense. The holder of a patent in an area critical to public health or climate change mitigation should be subject to minimal access obligations, assumed either through ex-ante conditions at grant or exposed through procedure legal conditions, or through mechanisms to stimulate voluntary licensing. This repositioning does not mean the cancellation of the right to exclusivity, but the introduction of social counter guarantees. Transparency regarding licenses conditions, the obligation to negotiate in good faith in the case of licensing requests for public purpose, remuneration assessment mechanisms that take into account the need for access for vulnerable countries, and the existence of innovation incentive schemes. Can be master reform architecture articulated on 3 interdependent pillars: conditional administrative acceleration, clear the predictable legal flexibility, financial and institutional support instruments for technology transfer. The main risks include under incentivizing private research if compulsory licensing are perceived as unpredictable or punitive, risk of capture of voluntary mechanisms by large holders setting exclusive conditions, administrative difficulties for national patent offices with limited capacity, conflict between national regimes and international obligations. This risk can be mitigated by procedural clarity, fair remuneration, and compensation mechanisms. The European Charter of Human Rights has recently strengthened the link between human rights and the environment. In Verein Klima Seniorinnen Schweiz versus Switzerland, 2024, the court ruled that states have a positive obligation to implement effective measures to mitigate climate change. If a state fails to facilitate access to green technology due to rigid intellectual property enforcement, it may be found in violation of Article 8. This creates a powerful legal precedent for using compulsory licenses as a tool for climate justice. And the conclusion, transforming intellectual property law into a catalyst for the green transition requires a combination of administrative and legislative reforms. Accelerating examination for green technologies contributes to reducing the time to adoption, but only in synergy with the licensing mechanism that ensure fair access. The proposed model balances incentives for innovation with social obligation. The patent remains rights, but accompanied by conditions and safeguards that protect the public climate interest. At European level, recent initiative on the harmonization of compulsory licensing procedures show a favorable policy direction towards predictable instruments for intervention in situations of public interest. In practical terms, combining fast track with hybrid licensing mechanism and financial instruments to support local production offers the best balance between efficiency and equity. Thank you very much for your attention.
Thank you very much for your contribution. Very interesting, and of course, this reference to the European Court of Human Rights was again a reference which was made also previously, and the question how we can combine some institution of civil law to the question of environmental protection and special personal rights. And now we proceed to Mr. Eugenio Lucas from Portugal. I'm so sorry, but I cannot read the topic. But nevertheless, Mr. Lucas just told me that he will present this topic in English.
Good afternoon and good evening. Depends if the place you are in Portugal, Brazil, Poland. Dzień e boa tarde, boa noite a todos que falam esta maravilhosa língua que é o português e que nos deixa aqui nesta diferença de línguas muito interessante, mas de línguas muito difíceis, realmente ao placo. Como a professora disse, eu vou fazer antes de ser português. I want to begin by greeting the organization, Professor Fábio Veiga, and all the organization committee, and the members of this panel, and the moderator, Professor Magdalena. My name is Eugenio Lucas. I'm a law professor in the Polytechnic University in Leiria in Portugal, and the title of my communication is Between Exclusivity and Open Access, the reconfiguration of patent law in the era of green innovation. The central objective of this investigation is to analyze the interaction between patent law and green innovation policies from a legal, economic, and environmental perspective. It seeks to understand how patents may be adapted to promote an open, responsible, an ecological sustainable innovation model. The study also aims to provide a critical reflection on the role of the states, universities, and enterprises in the creation, protection, and dissemination of clean technologies, analyzing concrete examples of green licenses, patent pools, and international cooperation programs in sustainable technology, while proposing normative guidelines capable of integrating market incentives with principles of environmental justice and technology equity. Green innovations refers to the development or implementation of products, process, service, or business models that minimize negative environmental impacts and promote sustainability. The concept has gained prominence due to the mounting concerns over environmental degradation and the need to align economic growth with ecological responsibility. Some authors view green innovation as a subset of the broader concept of sustainable innovation, which comprises environmental, social, and economic dimensions. Although the terms green innovation, eco-innovation, and sustainable innovation are often used interchangeably, slightly conceptual difference may exist between them. In the context of the climate crisis and the transitions toward a sustainable economy, a structural tension has intensified between patent law and the emerging requirements of green innovation. The patent regime, designed to stimulate the creation through exclusivity and private appropriation of knowledge, now confronts the need for open access mechanisms, technological cooperation, and rapid diffusion of ecological solutions. The central legal question is the extent to which the current patent framework promotes green innovation and the transfer of sustainable technologies, particularly in developing countries, and to what degree instruments such as green patents, compulsory license, collaboration, knowledge sharing, effectively contribute to environmental technology sustainability. The literature concerning the role of IP rights, intellectual property rights, particularly patents in green innovation, is not conclusive. Some studies argue that IP protection is essential for incentivizing innovation and facilitating the transfer of green technologies. Others contend that strong IP protection may be detrimental to green innovators. The international IP system, after TRIPS, reinforced the position of patent owners, often restricting access to essential technologies, including medicines and green technologies. But the patent system resulting from TRIPS is not absolute and contains exceptions. In the field of green innovation, several alternatives mechanisms to patents are being discussed. I will talk briefly about 13 different mechanisms that are organized in 4 categories, and then in the paper and the article published will be more detail about these 13 mechanisms. The first category is thank you. First category, internal flexibility mechanisms within the patent systems. These are mechanisms provided within the patent regime itself that adjust, limit, and modulate exclusivity granted to the patent holder in order to balance incentives for green innovation with the public interest. One example is green patents, our colleagues just talked about, so I will not talk about. Compulsory licensing is a second mechanism consisting in authorization of the government permitting third parties to exploit a patent product or process without the consent of the patent holder. Third mechanism, non-patentability of certain type of inventions. Genes, for example, are discoveries, not a new invention, and therefore should not be patentable. Yet, many legal systems allow gene patents if certain requirements are met. Second category, alternatives to the patent exclusivity system. These are instruments that encourage free circulation of knowledge, cooperation, and the creation of technological commons employed by economic actors who protect or derive value from innovation without relying on patents. First mechanism on this second category, open source systems. Inventors can choose not to patent, but instead protect discoveries under open source inventions under open source principles, permitting the free use, provide that any improvements are also released openly. Second, trade secrets and first mover advantage. Companies may protect green innovations through trade secrets or being the first to market, first mover advantage, avoiding the costs and delays associated with patenting. We know it's always 2, 3, 4 years. This strategy is common in fast-moving sectors and among startups. Liability road system. In contrast to the exclusionary patent regime, a liability system allows anyone to use patent technology upon a payment of reasonable fees, and also competitive mechanisms. The third category is complementary economic and regulatory instruments. These are public policies mechanisms that operate alongside the intellectual property system to guide economic actors and encourage the development of green innovation through direct incentives and market correction measures. For examples, public financing models, public subsidies, innovation prizes, direct investment in research and development, and substitute or complement patents by promoting the development and dissemination of green technologies without IP restrictions. This may include government programs, innovation funds, and public-private partnerships. Environmental taxation. Environmental taxes on polluting activities may increase the quality of green innovations, even if they reduce the total number of patents by redirecting efforts toward the more effective ecological solutions. Environmental regulation, laws and regulatory standards that impose requirements that stimulate the adoptions and development of green technologies. The fourth and last category is national and international cooperation mechanisms. These are legal and institutional mechanisms that promote coordination among states, public bodies, international organizations, enterprise, universities, and civil society to develop, transfer, and diffuse green technologies. For example, enhanced knowledge repositories, improved open repositories of patent information, translated to additional language, and equipped with filters that identify expired patents, facilitate the adoption of green innovations. Collaboration and knowledge sharing. The third one, intellectual property right commons. These commons facilitate the transfer of IP and reduce the transaction costs through voluntarily pledged patent pools and collaborative platforms. Final considerations. The analysis developed throughout the study demonstrates that the actual legal regime of patents, historically structured to promote competition and reward individual inventiveness, now faces a paradigm shift imposed by the climate emergency and the urgent need for transition to sustainable development models. The analysis showed that patent protection, although still fundamental as an incentive mechanism, proves insufficient and at times counterproductive when applied rigidly and without considering the specificities of green innovation. We conclude that the solution does not lie in weakening IP protection, but in reorienting it towards a sustainable intellectual property new paradigm, grounded in the principle of environmental responsibility and the social function of knowledge, supported by increased public incentives for green research, the promotion of collaborative models between universities and enterprises, and the creation of international legal frameworks capable of harmonizing IP protection with the global commitments to climate mitigation. Thank you.
I'm sorry for being a bad policeman, but nevertheless, we have to just to be more or less timely. Then the next participant is Mrs. Daniela Serra Castillo, not present online. Online, because I have here on the paper in person. Sorry. Is Mrs. Sara Castillo on?
Hello. Hi.
Professora Daniela Castilho.
Okay. Thank you. Boa tarde. First one, I thought the. Okay, wait. Sorry.
Professora Daniela, estamos a ouvir. It's not listening to us. Professora Daniela.
A conexão da professora Daniela caiu.
Okay, so maybe the next one and then.
Okay. Next person is Lucas Pereira from University of Pará in Brazil. I am glad to be hosting such a panel with such eminent guests from another continent. The floor is yours, Mr. Pereira, and the topic is the reach of tax justice as a structural principle of the constitutional text. Very, very interesting topic, but we have only 10 minutes, Mr. Pereira.
Well, thank you, Professor Magdalena. So I promise you I'll do it in my 10 minutes. I have prepared a longer presentation, but it will be my pleasure to send it later to EcoJustice, and it will be posted public and you can check for further details if you like. So here I'll do briefly the main points of the presentation, so we will finish in time. And it's my honor to be here. I would like to thank Professor Fabio for the invite here from Moderator, who is a key partner in my academic career here. That brings me to the other side of the world almost. And I would like to thank Professor Marius Zaluki. I think that's the pronunciation, I'm not sure. I'm close to that, but it's okay. Who also is a friend that I made in Curitiba, in my city, when he was there to a speech also. So we're here now today to talk about many themes, but my one is tax justice. So, okay, this theme is important for me because in Brazil we have a tax reform last year that strictly inserted in our constitutional the principle of tax justice. And then I said, oh, I need to start thinking, what is tax justice? So first, I think it's important to make a differentiation from tax justice to fiscal justice, where fiscal justice is something broader, something more wide and open, where is related to the way that the state gets money, not only from particulars, this is the tax justice in my opinion, but we'll get there. The way that state spends money, public policies, public debt, and something way broader than the tax justice. That's just the first topic, the way that the state gets money from the particular, that is tax justice. Okay, if we say what is tax justice, then what is justice in this term, tax justice? Most of the people I read try to fit philosophical justice theory into the tax justice term. So what is that tax justice? For example, if we start to think about John Rawls, for example, a famous philosopher, we will have his two principles that he shortly, something complex in short, he starts with the view of ignorance, where someone won't know who he is in the society, if it's majority or minority, if he is ill or healthy. So based on that condition, he will think basically two major principles. First, everyone is equal, principle of equality, everyone have equal conditions. And second, equal liberty, sorry. And second, the difference principle, which says that the inequality is only justifiable if it is to improve the condition of the least advantaged in the society. That's the second principle. So basically, in John Rawls' theory, if we consider it a philosophical justice theory, it will justify a taxation where it's okay to tax more, who have more, economic conditions. So this will make the state redistribute this economic condition to the less advantaged. Okay, that's a philosophical theory, that's a rational theory, of course, it's a Kantian, so the theory is basically rational. But we have, on the other hand, for example, Robert Nozick theory. In utopia, state utopia, anarchy, state and utopia. So Nozick will basically consider just a society where everything I achieve is just in a just way, in a legitimate way, and the state should not touch this. The state should not interfere in none of these conditions. So making also short what is complex in Nozick theory, we will have a very different taxation system. So the state will only get from the particular what it needs, the minimum to keep safety, to keep the society existing in a minimum state. Okay, we have two different philosophical justice theories, both of them rational, both of them okay, both of them valid, but they start from different beginnings. They start from different beginnings. So another one that I bring now is Alasdair MacIntyre. Alasdair MacIntyre have a interesting thought because he realizes that both, for example, these both theories are rational, but they start from different beginnings. So we need to think in our society, what our society think about justice. Okay, what our society think about justice, and here is my proposal about tax justice. To see what our constitutional think about tax justice. So I realized that in our society thoughts is basically in our constitutional. So our tax justice will also be in our constitutional system. So, for example, in Brazil, we have a widely detailed tax system in our constitution. So it grants many protections to the taxpayers. Differently, for example, if we are going to analyze the Italy's constitution, where there's only two dispositives, two texts, legality and ability to pay. So in Brazil, the interpretation for that whole chapter in our constitution, that is the tax law, must find the tax justice that protects the taxpayer, differently from the interpretation that's given to the tax justice in Italy, for example, that have not a wide protection system to the taxpayer in the constitution. So thinking about that, when we say about tax justice, I have a main question that brings me here today. What tax justice are we talking about? We are talking about our favorite personal philosophical justice? Or are we thinking about the society justice, what our society considers is justice for that own society, basically on historical facts, on social facts, economic facts? Because if we are thinking about our own tax justice, we have a problem, and we cannot fit this in a philosophical tax justice, in a philosophical justice theory. Then my proposition is to find what is tax justice in each own constitutional system, to find what the society considers about tax justice. If we're doing different, I think we're following a different and not right path. Thank you.
Of course, I would like to comment on your presentation, having in mind what is in Polish constitution, especially Article 2, saying that the Poland is the democratic state of rule of law. So in this meaning, we have just to be legal, but on the other hand, we have to think about a nation as a source of powers. And thirdly, we have in Article 1 saying that the Republic of Poland is a common good. So these three principles, of course, they impact also the idea of the tax system in Poland. You haven't mentioned the general principles of the constitution in Brazil, but I know we do not have time because Yeah, okay, yeah, so I think that we should also adjust these general principles just to the idea of tax justice in constitution generally. Okay, I like very much constitutional law and comparative constitutional law, so this is only an intervention. And now we have Ms. Barbara Diana.
Daniela is online now.
Okay. So, yeah, of course. Daniela is here now. I just.
Boa tarde, professora Daniela.
Hi. Hello. Do you hear me?
Yes,
Do you-
dear.
Do you hear me?
Start 10 minutes.
Okay, 10 minutes. First one, thank you for could be here. I thought the presentation would be in Portuguese, and I realized only about 30 minutes ago that should be in English. So I didn't have enough time to practice.
Já pode fazer em português, não há problema.
But I may some. Okay.
Sim, pode fazer em português.
Posso fazer em português? Perfeito. Ok, então eu já tinha colocado. Ok, no problem. Ok. Meu trabalho de hoje é sobre evolução da contratação pública, da eficiência administrativa e inovação tecnológica. A contratação pública foi, por várias décadas, entendida predominantemente como uma função administrativa, um conjunto de procedimentos e formalismos focados na aquisição de bens e serviços e obras pelo menor valor possível. Sua principal preocupação residia na correção processual e no cumprimento rigoroso da lei, garantindo a gestão da despesa pública dentro de um quadro de legalidade restrita. Essa visão, embora essencial para a integridade da gestão pública, limitava o potencial da contratação a um papel meramente operacional. O poder do setor de compras públicas, no entanto, representa uma força econômica de enorme magnitude. Na União Europeia, a aquisição públicas envolve mais de 250 mil entidades, mobilizam anualmente mais de 2 trilhões de euros e corresponde aproximadamente a 14% do PIB comunitário. A dimensão desses valores evidencia que a contratação pública não é apenas um centro de custos, mas um poderoso instrumento em que o Estado dispõe para influenciar o mercado e as políticas públicas estratégicas. Então, ao longo da minha apresentação, vou fazer uma análise de como os conceitos foram mudando com o tempo. O enquadramento europeu, que foi catalisador da mudança, ou seja, a principal força motriz para a modernização e harmonização da contratação pública nos Estados-membros, tem sido o enquadramento jurídico da União Europeia, através das diretivas que os Estados-membros começaram a ter maior preocupação sobre o setor da sustentabilidade, inicialmente com os limiares comunitários para o serviço público tradicional, novos limiares comunitários, cujo objetivo é garantir um mercado único, aberto, transparente e competitivo. Essa harmonização tem sido não só fundamental para assegurar a liberdade de circulação de bens, serviços e capitais, mas também introduzir progressivamente uma visão estratégica sustentável das aquisições públicas. Já nas diretivas de 2004, assinalaram os primeiros passos à integração e preocupações extracomunitárias, extraeconômicas, aliás. Nos seus considerandos dessa diretiva, já havia uma referência que as entidades adjudicantes deveriam contribuir para a proteção do meio ambiente e promoção do desenvolvimento sustentável. a diretivas de 2014 que vem a consolidar a visão estratégica. Estas diretivas de 2014 surgiram no contexto particular do rescaldo da crise financeira de 2008 a 2011 e no âmbito da estratégia europeia 2020, que visavam o crescimento sustentável e inclusivo. Esse enquadramento moldou a visão das diretivas de 2014 e colocando alguns objetivos principais, como a simplificação e flexibilidade, a segurança jurídica e transparência, a utilização estratégica da contratação pública e o apoio às pequenas e médias empresas e startups. A mudança de paradigma deste conceito de contratação pública não é um diploma distinto ou um ramo autônomo do direito, mas sim uma nova forma de olhar e utilizar a contratação pública. Representa uma aplicação mais inteligente e intencional das regras que já existem, com o objetivo de otimizar os recursos públicos e, mais importante, aperfeiçoar os resultados obtidos, alinhando aquisições com objetivos de governação a médio e longo prazo. Aqui se pode ver, nesse slide, esta mudança de paradigma de uma forma mais clara, com a perspectiva tradicional e a perspectiva estratégica. Por exemplo, antes havia um fraco planeamento em processos mais inflexíveis, agora temos um foco mais em critérios qualitativos e funcionais, uma procura também do valor agregado para a sociedade, entre outros dos detalhes que vocês conseguem ver nos dispositivos. Portanto, se pensa que passou de como comprar para o que comprar. Da essência dessa transformação reside na passagem de uma preocupação quase exclusiva com a correção procedimental, o como comprar, para uma preocupação diferente, uma preocupação que gera valor para a sociedade, o que comprar. O objetivo deixa de ser apenas a aquisição de um bem ou serviço a um preço mais baixo e passa a ser a procura do best value for money, a melhor relação qualidade e preço, considera o impacto social, o impacto ambiental e a inovação de longo tempo e o ciclo de vida do produto ou serviço. Portanto, esta abordagem exige também uma mudança cultural. Entre os pilares da contratação pública sustentável, materializa-se em três formas, em três dimensões: uma dimensão ambiental, das compras ecológicas, uma dimensão social, compras socialmente responsáveis, e uma dimensão econômica e da inovação. Nesses dispositivos está a introdução dessas normas no Código dos Contratos Públicos português, que eu não vou me aprofundar hoje, porque depois, quem tiver interesse, pode ler o artigo mais completo. Nos desafios e oportunidades, se destaca como desafio a falta de consciencialização e capacidade técnica, algumas restrições orçamentais, a resistência a mudanças, a dificuldade em medir o impacto dessas mudanças e a falta de disponibilidade no mercado de alguns produtos com critérios de sustentabilidade, que ainda é bastante limitada. Algumas recomendações que poderia se fazer para a implementação efetiva da compras públicas, estratégias em matéria ambiental, seria definir políticas mais claras, capacitar e sensibilizar os profissionais da contratação pública é crucial, uma partilha de boas práticas também, começando gradualmente, envolver o mercado, monitorizar a execução. Já indo diretamente para as conclusões, para não tomar mais tempo, posso dizer, então, que a contratação pública estratégia sustentável não deve ser vista como uma mera obrigação legal, mas uma oportunidade fundamental para o Estado utilizar o seu considerável poder de compra para promover o crescimento econômico mais justo, uma sociedade mais inclusiva, um futuro ambientalmente responsável, ao privilegiar soluções que geram valor para além do preço. A administração pública pode catalisar a inovação do mercado, fortalecer as economias locais e garantir que cada euro gasto contribui para uma construção de um bem comum duradouro. Então, o futuro da contratação pública aponta para uma integração irreversível de critérios ambientais. Esse cenário, como já disse, exige uma mudança cultural proativa e profunda dentro da administração pública, transformando cada procedimento de aquisição numa oportunidade para fazer não só o que é legal, mas o que é certo para a sociedade e para as sociedades futuras, essa ideia de sustentabilidade. Muito obrigada pela atenção prestada. Thank you.
Thank you for your presentation, and especially that the slides were in English, which helps us very, very much. The next participant is Mrs. Barbara Diana Brazil, from University of Autonomic University from Brazil. Could you please start your presentation? Mrs. Brazil told me also that it will be at least partly in English, so I'm very glad. I cannot read the topic, but if you could also present the topic of your presentation.
Thank you. Good evening, everyone. It's a pleasure to participate in this EcoJustice event and in this traditional university. My name is Barbara. I am professor at Centro Universitário do Brasil in Curitiba, in the state of Paraná, and a postdoctoral researcher in public law and fundamental rights. My work focuses on human rights, democracy, and corporate accountability. Today, I present my paper entitled The Contribution of the European Corporate Due Diligence Directive to the Characterization of Corporate Complicity and Human Rights Abuses. This topic is part of a broader debate on the corporate accountability for human rights violations, particularly in global value chains, and the limits of voluntary regulatory approaches. Corporate complicity in human rights abuses is widely acknowledged in international human rights law, yet it remains difficult to apply in practice. In many cases, corporations do not directly commit violations, but contribute to benefit from or fail to prevent abuses, especially through subsidiaries, suppliers, or business partners. Traditional accountability frameworks face persistent challenges, including fragmented transnational supply chains, evidentiary difficulties related to the knowledge and contribution, and the absence of clear binding obligations. Against this background, the European Corporate Due Diligence Directive emerges as an attempt to address these structural gaps. The main objective of this paper is to analyze how the European Corporate Due Diligence Directive contributes to the legal characterization of corporate complicity in cases of human rights abuses. The paper argues that the directive strengthens not only preventive duties, but also the legal identification of key elements of complicity, such as knowledge, contribution, and causal link. The directive introduces binding due diligence obligations for certain companies operating within the European Union, covering human rights and environmental impacts. Three aspects are central. First, the obligation to identify and assess actual and potential risks through the value chain, including subsidiaries and business partners. Second, the duty to adopt appropriate measures to prevent or mitigate identifiable risks, moving beyond purely formal compliance. Third, the possibility of civil liability when companies fail to comply with due diligence duties and harm occurs. Although the directive has been postponed and its scope has been narrowed, it still represents a shift from voluntary standards to mandatory corporate responsibility. The core argument of the paper is that the directive contributes to the characterization of corporate complicity in three main ways. First, regarding knowledge, by requiring systematic risk assessments, the directive significantly weakens claims of ignorance. Second, regarding contribution. Legally relevant contribution may arise from significant omissions, particularly when companies fail to prevent or mitigate foreseeable harms. In this sense, omissions can amount to complicity. Third, concerning the causal link, the directive facilitates a clear connection between corporate conduct and resulting human rights abuses, especially where compliance with due diligence obligations could reasonably have prevented the harm. For a practical perspective, the directive enhances access to justice for victims, increases legal certainty, and encourages changes in corporate behavior. At the same time, important limitations remain, including the postponement of implementation, the reduced personal and material scope, and continuing evidentiary challenges. Nevertheless, even in its more restricted form, the directive still represents a meaningful step forward in addressing corporate impunity. In conclusion, the European Corporate Due Diligence Directive does not redefine corporate complicity as a legal concept. However, it significantly improves its legal operability. By establishing binding and enforceable due diligence obligations, the directive reduces normative uncertainty and strengthens corporate accountability for human rights abuse. The key challenge now is ensuring effective implementation so that this regulatory framework leads to real changes in corporate practice and better protection for victims. Thank you very much.
You still have 5 minutes because I consulted your statement till 7:15. That's why I would like to ask you a question, because you just described the concept of the due diligence from the perspective of the European Union law. But nevertheless, do you perceive these guarantees as effective when it comes to the trade relation between Europe and South America countries?
This is right the point. I see that the European Union directive can apply to business that have value chains with partners in Brazil, for example, and that have many impacts on social rights, on a kind of human rights, in even the question of environment. All these questions are related to the way the corporations work and the direct and indirect effects of this work can be felt by persons who live there. So we think that the European directive can help to make these companies to attempt to human rights and not causes many abuses as we can see today.
Okay, if you would be a legal advisor to a company here in European Union, what would be your advice to the company on which elements should the company focus when invest, for example, money in Brazil or buy any goods in Brazil, having in mind the directive? What are the threats? What are the main points of concerns for the European company who would like to be legal in the scope of the directive?
I would strengthen the context of the operation. It's not only to go there and make investments. We need to see what's around. It's a country that have many problems, social problems, and of course that this should be addressed by business because in certain aspects, they are favored by the legal requirements of our country. So we don't have the same regulation regarding some human rights aspects. And when some companies go to countries less developed, they favored from this condition, this legal condition. So it's necessary that they attempt to the contest in their operation because it's going to have effects not only for people who live there, but still for democracy.
Thank you very much for contribution. We still have 2 minutes, so we are perfect, panelists in this way. If I could only suggest to write in a paper, also from this implementation of the directive, but precisely from the perspective of Brazil. It would be very interesting from European investors and European companies. Yeah. Thank you for your contribution, and we have the last guest here in Krakow. This is Ana Carolina Matos Figueiredo. I would like also to ask Eugenio to be a moderator. Okay. Yeah, because as I assume the person. Okay, Mrs. Carolina Figueiredo, do you speak English either?
Yes, I speak English.
Sorry for because your topic is in Portuguese. That's why I thought you do not speak English. So could you please present your topic in English?
Okay.
Because it'll be in Portugal or in English either.
Okay. In English, I would say it's the legal framework of space debris in the European Union towards a policy of orbital sustainable.
Okay. Thank you very much. Do you have a presentation to share with us?
No, sorry about that. I'm just going to speak.
Okay, so we will welcome you and we are waiting for your presentation, please. You have your floor, 10 minutes, please.
Okay, thank you very much. Good afternoon to all distinguished doctors present. My name is Ana Figueiredo. I'm a PhD candidate in criminal science at University of Coimbra. Before I begin, I would like to apologize to distinguished members for my panel for my horrible voice because with the rust of a flu. I hope, nevertheless, I'll be able to be clearly and cover the essentially points from my presentation. That being said, today I will address a topic that has gained increasing prominence in public, scientific and legislative debate. It's space debris, and in particular, the recent European Union legislative proposal amend the regulations of this phenomenon. The title of my article, as I said, is precisely the legal fragment work of space debris in the European Union towards a policy of orbital sustainable. We are currently living a time when the internet, global navigation system, communications, and even climate observations depend heavily on satellites and orbital infrastructure. For example, at this very moment, this presentation it's taking place via Zoom. I'm from Portugal. I'm here in Portugal, and I'm talking to you. I can be able to communication in real time with the distinguished scholars location in Poland. And however, this technological progress comes with a cost. The space surrounding the Earth, it becomes increasingly congested with space debris, much of which pose real risk to space operations and to the future of space exploration. What is space debris and why is that problem? Space debris refers to all artificial objects in Earth orbit that no longer serve any useful purpose, including the phantom satellites, rocket stage, and fragments resulting from collisions or disintegrations. These objects travels at extremely high speed, up 10 or 1,000 kilometers per hour, which means that even a small fragments can cause several damages to satellites or spacecrafts. Beyond the mediated risk, there is also a systemic problems known as the Keller syndrome. It's a scenario in which successful collisions generates increasing amount of debris, rendering certain orbit almost unusable. This phenomenon may be described as a chain reaction or domino effect. The amount of space debris in orbital. According to the environment reporting from European Space Agency from 2025, there is more than 40,000 pieces of space larger than 10 centimeters and over than 1 million debris objects between 1 and 10 centimeters. And the total mass in orbit of these objects, it's current on Earth orbit, it's approximately 15,000 tons, including satellites, rocket states, and non-collision debris. This amount is comparable to the weight of several landmark buildings and clearly demonstrates that the problems is not limited to the microscope fragments. There is a substantial quantity of material continuous circulation in orbit. The strategic importance of space for the European Union. The European Union views the space not merely as a technical or scientific field, but as a strategic component essential to the modern societies. As I said, satellites are fundamentals for global communications, navigation systems, environment and climate monitoring, security and defense. The growing dependence of these technologies makes the orbital environment a common good that requires regulations, protections, and long-term sustainable. The gaps that it's in current legal framework of and the European proposal. Until now, the space regulation has relied primarily on international treaties from the mid 20th century. I would say 1967. There was the Outer Space Treaty, which implements general principles but do not provide detailed rules of spatial debris, liability, or debris mitigations. This normative gap lead to the European Commission's the proposal that the US Space Act amends to harmonize national laws of the US member states, introduce mandatory standards for safety and orbital sustainable, and enlargement mechanisms for holding space operations accountability. According to the Article 1 of the US Space Act proposed, the regulations is essentially based in 3 pillars. It's safety, resilience, and sustainability. It's also important to highlight that the US space provides that its provisions shall apply not only to European and national space operations and space service providers, but also operations from third countries insofar as they offer their service within the European Union. The main companies of the US Space Act. The proposal requires that any space operation subjected to the EU law must submit a space debris mitigation plans, monitoring and tracking the objects, and the legal liability. I can say more about the legal liability. The proposal also introduces clear rules within EU law regarding operations liability. If a space activity causes damage, for example, a collisions that generates debris or damage of third-party satellites, the responsible operator may face sanctions and compensation obligations. This effectively applies that the polluter pays principle to the orbit environment, transforming what was implies, now it's applies to the law. Space and environment to be protected. One of the most significant contributions of this European initiative is the recognition that orbital space forms an integral part of the global environment, even though it lies beyond the Earth itself. By fragment space debris as both as an environment and technological issue, the EU plays other space within a paradigm similar to the terrestrial environmental law, knowing that without a sustainable orbital environment, all use of space are ultimate to risk. The EU legislative actions may also serve as a normative model at the international level, encouraging other states to adopt similar standards or to cooperate in more robust multilateral agreements. In doing so, the European Union positions itself as the key actor in a sustainable global space governance, promoting rules that go beyond voluntarism in order to strengthen safety and responsibility. To conclude my presentation, I can say that space debris is a real, growing and systemic problem with tens of thousands of tracked objects and more than 15,000 tons of artificial material currently orbiting the Earth. This phenomenon directly threatens the safety of the space operations, the sustainability of the orbital environment, and in the medium and long term, our critical dependence on essential space-based service. It's important to treat that Earth orbital environment. It's a finite research whose degradations may irreversible compromise safe access to space. The European Union legislative proposal represents a decisive step toward the creation of a clearer, coherent, and harmonious legal fragments, strengthens operational accountability, promotion sustainable practices, and integration technology innovation as a central part of the solutions. And finally, by adopting action standards on this issue, the European Union affirms itself as a key actor in global space governance, contribution to the development of more demanding cooperation standards aimed at protections, a common heritage of humankind. Ultimately, the way we manage space debris today will determine whether outspace remains a dominant of opportunity or becomes a constraint of future technology progress. Thanks very much for your attention. I'll finish my presentation.
For your presentation, I would like to ask the last question. Do you perceive that it's necessary also to conclude an international agreement besides the European Union regulation, because this addresses only the European Union companies?
Can you repeat, please? Sorry.
I was just asking about the need to conclude an international agreement to the party, which would be the global actors or global actors, because you talk only about the European Union regulation. Okay.
I didn't understand your question. Sorry.
Okay. So maybe it's too late to ask the questions. Thank you. Thank you in the name of the EcoJustice, which is the organizer of the panel, and also the Ignatian University here in Krakow. And I hope we will learn more about your topics, having in mind that there will be a book about it, and we publish our articles, and we will be able to have a little bit deeper exchange on the topic. Thank you very much once again, and see you maybe tomorrow online during the panel.
Thank you.
Yeah.